Welcome to Silence Screams Lost Strength. I'm your host, Samantha. This is Unmasking Justice series. Today we are moving beyond surface level discussion to conduct a forensic analysis of what really happens when professional standards, legal duties, psychological dynamics, and legal process collide. We are looking at how the very structure of the legal profession, the commercial pressures within it, and the strategic tactics used by those with power can turn what should be a process of justice into something that serves interests other than the truth. So crucially, we will examine where the binding codes of conduct and regulatory principles that govern the legal professions are being broken and how this creates harm, undermines fairness, and violates the very laws and standards that exist to protect people. So, the legal analysis at its strongest, rooted in law, regulation, and evidence. This is the paradox of power and position when status and interests collide in legal duty. Let's start with the paradox that many people find impossible to understand. We have a system that is designed to deliver justice based on facts, law, and professional integrity. Yet we see situations where power, connections, resources, and professional standing appear to override every legal duty and ethical principle. I want to talk about what happens when a case moves from being heard by a judge who is focused on the evidence, the merits, and the legal obligations to being handled by a different set of professionals. We see this dynamic play out repeatedly. Cases that being with a judge who understands the facts, who has already recognized the nature of the issues and put safeguards in place, then move into the hands of a legal team that operate at the very highest level of their profession. We are talking about teams that include part-time judges, barristers who specialize in what are deliberately presented as highly complex legal issues, and partners in major law firms based on the chancery lane, and those that describe themselves as operating in the magic circle level. These are firms that command the highest fees, employ leading experts, and have the resources to shape how cases can be managed, presented, perceived. And we also see individuals within these teams who contribute to major national media outlets whose profiles and influence extend beyond the courtroom and into public discourse. And here is the reality we have to face when this level of presentation is paired with a narrative that claims a case involves substantial legal complexity or unique structural issues. We see a clear pattern emerging. That pattern has nothing to do with the actual facts of what is happening or the real issues that need to be resolved. It is the pattern that serves a different purpose entirely. And in doing so, it violates the core legal ethical standards. So let me be clear, I am not saying every professional or who works at this level acts in this way. There are many who uphold the highest standards of integrity and service, but I am describing a dynamic that we have seen repeatedly in real cases, one that is recognized in legal practice and which needs to be examined openly because it changes how justice is delivered for everyone involved. It is an interest for the public. Under the Bar Standards Board, BSB Code of Conduct, which applies to all barristers in England and Wales, there are fundamental duties that must be followed at all times. These are not optional guidelines, they are binding obligations, and breach can result in serious consequences, including being disbarred. The core duties are duty to the court. Rule 1.1 states that a barrister must at all times act in the best interest of the administration of justice. This is the primary duty. It overrides any duty to the client, any financial interest, or any personal or professional ambition. Duty to act with integrity. Rule 2.1 requires barristers to act with integrity, which means being honest and open and not engaging in conduct which is discreditable or likely to diminish public interest and confidence in legal profession. Duty to provide accurate information. Rule 3.3 requires barristers to take reasonable steps to ensure that information they provide to the court is accurate and not misleading. Duty to act fairly. Rule 3.4 states that barristers must act fairly towards all parties, including opposing parties and their representatives, if they are represented. So when cases are deliberately expanded, when complexity is treated where none exists, and when narratives are constructed to serve commercial or strategic goals rather than the interests of justice, these core duties are broken. The duty to the court is displaced by the other interests, and the principles of integrity, accuracy, and fairness are compromised. So the business model, when billing becomes more important than legal duty. One of the most disturbing realities we face in the way in which family proceedings can, in some circumstances, be turned into a commercial model where generating income becomes the priority and resolving disputes or delivering justice becomes secondary. We have to ask difficult questions. When does a case stop being about resolving a dispute and start being about generating revenue? When does complexity become a tool rather than a fact? The culture within parts of the legal system creates an environment where more work means more fees, more hearings mean more income, and more layers of documentation mean more charges. When that becomes the dominant priority, the focus shifts from reaching a fair outcome to generating work. This is not a failure of the laws themselves. The legal frameworks or the legal framework we have is built on strong principles, but it is a failure of how the system is sometimes operated, and it directly violates the binding duties that govern the profession. So let's look at how that plays out in practice and where legal standards are broken deliberately. They are broken deliberately. Expansion of simple cases that could be resolved fairly and quickly are deliberately expanded. Issues that are simple and straightforward are presented as complex legal matters that require extensive research, multiple hearings, and detailed submissions. What is actually clear and simple becomes something that appears mysterious and difficult, simply to justify high costs and longer proceedings. So, breach of duty under BSB Code of Conduct Rule 1.1. The barrister primary duty is to the administration of justice, deliberately creating unnecessary work, prolonging proceedings without proper legal justification, and presenting simple issues as complex directly violates this duty. It also breaches Rule 3.1 as the information provided to the court is misleading. It does not reflect the true nature and complexity of the issues. So reframing facts to create complexity, assets and finances that can be verified and explained clearly are reframed using complex terminology and elaboration of documentation, not to make the truth easier to understand, but to create a narrative that is hard to challenge and which requires further legal work to unpick. So, breach of conduct. This violates the duty to act with integrity, Rule 2.1, and the duty to provide accurate information. So, Rule 3.3, when facts are reinterpreted in ways that distort their true meaning, and when documentation is used to create confusion rather than clarity, the barrister is failing to act honestly and openly and is providing information that is misleading to the court. This example of financial records, when we see financial records involved, this pattern becomes particularly obvious. For example, £500,000 money that represents years of work, effort, and sacrifice. Money that can be traced through bank statements, company accounts, and official documentation is suddenly presented as a red herring. Let's be clear about that. That means a red herring is something introduced to distract attention from the real facts in issue. When a clear, verifiable sum of money is dismissed as irrelevant, misleading, it is not because it has no connection to the case. It is because it does not support the narrative that is being built. The narrative that has been constructed does not align with the facts, so that facts are reframed to fit the story. That's breach of duty. This is a clear breach of duty to the court and the duty of accuracy. The barrister is representing information that they know or ought to have known is relevant and material to the case as if it has no significance. This is misleading the court, and it is it directly undermines the administration of justice. It also breaches Rule 3.4 because it treats the opposing party unfairly by distorting the evidence and making it harder for them to present their case. And in this, and this is how domestic abuse, coercive control can become part of the model when someone has been controlling or manipulating a situation. They have the resource to sustain lengthy proceedings. They can turn their actions into a narrative that is presented as legitimate legal work. The harm they have caused can be hidden behind layers of arguments, and the truth can be obscured behind complexity. The people who suffer most from this are the vulnerable parties, those who have already experienced trauma, abuse, control, who do not have the resources to match the level of operation, and who simply want the truth to be heard and a fair outcome to be reached. So, tactics that distort truth and process and the legal duties they violate. There are specific tactics that we see used repeatedly and which directly affect the principles of fairness and equality of arms that are at the heart of our justice system. These tactics are not random. They are deliberate, strategic, designed to gain advantage, and they can violate the core legal regulatory standards at every stage. So, moving jurisdictions to change the outcome and rewrite a new narrative. We have seen cases where, after a victim has established their position, where safeguards have been put in place to protect them, and where the facts of the case have already been considered and understood the legal team for the other party, and when the other party's legal team takes action to move the case to a different jurisdiction, this is not about finding a more appropriate place to hear the case. It is about finding a place where the dynamic are different, where the understanding of the issue may be less developed, and where the advantage can be shifted back to them. So once a case is moved, all the progress made in the original location where the merits were considered and protection was in place is often discarded. The new legal team then has complete space to introduce new narratives, new arguments, and new ways of presenting the facts. So, legal and regulatory context. The rules governing jurisdiction in family courts are set out in legislation and case law, including the Family Law Act 1996 and the Civil Jurisdiction and Judgment Regulations 2015. These rules are designed to ensure that cases are heard in the most appropriate place to achieve justice, taking into account the connections between the parties, the evidence available, and the needs for fairness. So, moving jurisdiction for the purpose of gaining advantage, avoiding established safeguards, or changing the base on which the case has been considered is a breach of these legal principles. Under the BSB Code of Conduct, this also violates the duty to act in the best interest of the administration of justice. If a barrister advises or acts to move jurisdiction without proper legal justification, they are acting in a way that undermines the proper functioning of the court, and they are failing to uphold their core duties. This can also constitute professional misconduct, as it is conduct that is discreditable and damages public interest in the legal system. So creating complexity where there is none. We often hear claims that a case involves complex legal issues or substantive financial matters. But when we look behind these claims, we frequently find that there is no genuine complex or only complexity that has been created deliberately. This is what happens in simple facts. If simple facts are presented in a complicated way, documents that are clear and verifiable are reinterpreted to create confusion. Narrative is built not around what is true, but around what will be difficult for the other side to challenge. We have seen where clear sums of money are described in ways that make them appear mysterious and then dismissed as irrelevant. When they do not fit the story, they are reframed to suit the other side's narrative. So legal regulatory context, the law requires that cases are managed efficiently and fairly, and that issues are presented clearly so that they can be properly understood and decided. So the Civil Procedure Rules 1998 place a duty on all parties and their representatives to help the court further the overriding purpose of the rules, in which to deal with cases justly at proportionate cost. Creating complexity where none exists is a breach of this principle, and it violates the duty of barristers to provide accurate and clear information to the court. The BSB Code of Conduct Rule 3.3 also requires barristers to avoid making misleading statements or taking misleading actions, and that includes actions that create unnecessary confusion or complexity for the purpose of gaining advantage. It also breaches the duty to act fairly because it puts the opposing party at significant disadvantage by making it harder for them to understand and respond to the case and the facts in issue. So the power of the narrative over evidence. In a legal proceeding, evidence should always be the foundation of the decisions. But when powerful legal teams use skilled barristers and specialists representing a narrative that can become more important than evidence, we see how this works now, where a professional CV with impressive credentials and experience is used to build authority. The person representing the argument is positioned as an expert, and their views are given greater weight even when those views are not based on fact or law. Stories are constructed that fit that client, that fit the client's wants to achieve rather than what actually happened. These stories are constructed carefully, presented with confidence, and supported by layers of documents that may be selected or interpreted to support the narrative. Facts that do not fit the story are downplayed, dismissed, or explained away. The truth becomes whatever is most convincing rather than whatever is most accurate. So the legal and regulatory context, this directly violates the fundamental principle that decisions must be based on evidence and law, not persuasion or presentation. It breaches multiple provisions of the BSB Code of Conduct. Duty to the court. The barrister must ensure that the court is not misled and that arguments are based on legal principle and reliable evidence, presenting constructed narratives as fact fails to meet the obligation. So duty of integrity, presenting a version of events that is known to be inaccurate and using credentials to give false weight to arguments is dishonest and discreditable conduct. So duty to act fairly. By presenting a one-sided, misleading version of events, the barrister is failing to treat the opposing party fairly and is preventing the court from seeing the full picture. So, duty to provide accurate information. When arguments are based on selected or distorted evidence, the information provided to the courts is not complete or accurate. This is a direct challenge to the principle of justice. The law requires that decisions are based on fact, on evidence, and on the application of legal principles. When narrative becomes the driving force, and when power and presentation counts more than truth, equality of arms is destroyed, and the legal duty that are meant to prevent this are broken. So now let's look at the psychology of control, behavior as strategy, and the duties that govern it. When we look at these dynamics, we see clear patterns of behavior that appear repeatedly, both in personal relationships and in legal proceedings. These are not just random actions, they are strategies used to maintain control and gain advantage. We commonly see selective disclosures, sharing only information that supports one side's position, while hiding or omitting what does not. Narrative reframing, presenting events in a way that challenges or changes their meaning or context. Minimizing of harm, downplaying the impact of actions or behavior. Projecting of blame, shifting responsibilities to the other party rather than accepting accountability. These behaviors align with psychological defense mechanisms that are often linked to specific personality structures. They are driven by the need or a need to perceive self-image, avoid shame, and gain and maintain control over how events are perceived in general terms. What this means is, in simple terms, is when a case comes to court, the judges are not just evaluating evidence, they are evaluating two competing systems of presentation, of presenting two different ways of telling the story of what happened to get fair outcomes we need to understand not just what is said, but why it is being said and what patterns lie behind it. This is particularly important when we consider coercive control. Coercive control is not like an accident or a single event that can be easily proven. It is complex by nature, it is cumulative, it develops over time, and its impact builds gradually. So in legal context, under the Domestic Abuse Act 2021, Section 1, domestic abuse includes controlling or coercive behavior, and the Serious Crime Act 2015, Section 76, defines such behaviors as repeated or continuous conduct that has a serious effect on the victim. The law already requires the courts to look at the patterns and cumulative impact, but in practice, presenting that pattern as clear, reliable evidence is not always straightforward. And because the court's proceedings often happen over a relatively short period of time, while abuse unfolds over months or even years, we risk losing the detail and the context that is essential to understand what really happened. This creates a structural disadvantage long term. Patterns can be reduced to snapshots, and important details can be lost or misrepresented. So, regulatory context. When barristers act to represent behavioral patterns in a misleading way, or to hide or to distort the nature of coercive control, they are breaching their duties. They have the duty to ensure the court understands the true nature of the conduct in question and to present evidence accurately and fairly in full, frank. Failing to do so is to breach the duty of the court, the duty of integrity, and the duty to provide accurate information. It also violates the public's interest because it prevents the legal system from addressing the harm caused by domestic abuse, coercive control. So, procedural vulnerabilities, where the system can be exploited and how duties are broken. Even with strong legal laws and powers in place, there are areas where the system can be vulnerable to exploitation. These vulnerabilities create opportunities for those with resources and influence to gain an unfair advantage, and they become the environment where the breaches of legal and regulatory standards we have discussed take place. Let's examine these areas in detail and understand exactly how they are being misused. So, credibility and presentation. Where a court assesses who is telling the truth, they look at credibility, but how someone presents themselves can be misleading. And this difference in perception is often used strategically. We are guided by the foundation of the case of R.V. Lucas, 1981, which sets out the principles that courts must follow when assessing the credibility of witnesses. The case makes it clear that a person's behavior, manner of speaking, and the ability to recall are all factors to consider, but they must be interpreted carefully and cannot be taken as sole or primary evidence of truth. This is particularly important because of the impact that trauma and control have on people. Victims of abuse and coercive control often experience significant psychological effects that change how they present themselves. They may appear consistent when describing events, not because they are lying, but because trauma affects memory and recall, and events may be experienced as fragmented or difficult to put into words. They may struggle with recalling details, not because their account is untrue, but because the events are painful, overwhelming, or have been distorted over time. They may show emotional responses such as distress, hesitation, or uncertainty, reactions that are unnatural and understandably given that they have been going through, but which can be misrepresented as signs that are unreliable or untruthful. At the same time, those who use controlling behavior often learn to present themselves in a way that appears confident, composed, and convincing. They may structure their arguments and evidence with great care, presenting themselves as logical, rational, and trustworthy. This is not because their account is accurate. It is because they have developed skills to manage how they are perceived and to create an impression that preserves their interests. This difference is presented in presentation creates a serious risk. The person who appears more confident or organized is often mistakenly seen as more credible, even in their account. Even if their account is not true. It is not just misunderstanding, it is a vulnerability that can be deliberately exploited. Breaches of duty and legal standards under the BSB Code of Conduct. Barristers have a specific duty to ensure that the court understands these dynamics and present evidence in a way that allows for a fair assessment of truth. Rule 3.3 requires barristers to provide information that is accurate and not misleading. And this includes not misleading to the court about the significance of the party's behavior or presentation. So when barristers use these differences in presenting or creating a false impression of credibility, they are acting in breach of this duty. They are not presenting evidence fairly, and they are preventing the court from making an accurate assessment of the facts. This also breaches the duty to act fairly towards all parties because it puts the vulnerable party at a significant disadvantage by distorting how their evidence is perceived in court. Legally, this also violates the principles set out in R.V. Lucas. Barristers have a duty to ensure that arguments about credibility are based on proper legal principles and evidence, not misleading impressions or assumptions. So equality of arms versus equality of capacity. The right to a fair trial is guaranteed under Article 6 of the European Convention of Human Rights, which is incorporated into UK law through the Human Rights Act 1998. A core part of the right is what we call equality of arms, the principle that both parties to a case must have a fair and equal opportunity to present their case, challenge the evidence against them, and respond to arguments made by the other party. But as the European Court of Human Rights noted in the landmark case of Steele and Morris versus United Kingdom 2005, equality of arms is not just about having the same legal rights. It is also about having equal capacity to exercise those rights. This means that fairness cannot exist if one party has a greater resource, knowledge, experience, or support than the other party. In family proceedings, this distinction is crucial. We often see cases where one party has access to top-tier legal representation, including barristers from leading chambers and firms with extensive experience in complex litigation, substantial financial resources to cover legal costs, expert evidence, and other supports. Professional advice and guidance from experts is strategy, evidence, presentation, and case management. Access to networks, influence, and connections that can shape how the case is managed and perceived. So meanwhile, the other party often is a victim of domestic abuse or coercive control and financial control, may face limited to no financial means, making it difficult for them to or impossible to access equivalent legal support. The effects of trauma, which can affect their ability to understand legal processes, present their evidence effectively, or respond to complex arguments. Lack of knowledge also about how legal systems work and how to navigate it or navigate the procedure. The emotional distress, the uncertainty in which can make it harder to maintain their position or present to tactics used against them. When this imbalance exists, equality of arms is destroyed. The party with greater resources and capacity is able to use those advantages to shape the process, to control the narrative, and to gain outcomes that could not be possible if both parties were on a level playing field. So breaches of duty and legal standards under the BSB Code of Conduct. Barristers have the duty to act fairly towards all parties, Rule 3.4, and to act in the best interest of the administration of justice, Rule 1.1. When a barrister uses their superior skills, resources, or position to gain unfair advantage over an opposing party who is at a disadvantage, they are breaching these core duties. This is not just a matter of professional conduct, it is a violation of the fundamental human rights. The court have repeatedly confirmed that equality of arms is essential to a fair trial, and that when this principle is undermined, the outcome of the case may be unsafe or unjust. Barristers also have a duty to ensure that the court is aware of any significant imbalance between the two parties and to act in a way that helps to mitigate unfairness rather than exploiting it to gain advantage. Failing to do so is a serious breach of professional standards. So let's talk about participation and vulnerability. The legal framework governs or the legal framework governing the family proceedings requires or recognizes that some people are more vulnerable than others and require special measures to ensure they can participate fully and effectively in the process. These requirements are set out in legislation, rules for the court, and professional standards. So, under the Family Procedure Rules 2010, Part 3A, the court has a duty to identify a party or a witness if vulnerability and if they have taken appropriate measures to support their participation. Practice Direction 3AA and 12J provides detailed guidance on how to support a vulnerable person or persons, including measures such as providing information in accessible formats, allowing extra time, providing support workers, or adjusting the way evidence is given. The BSB Code of Conduct requires barristers to act with compassion and understanding towards others and to take reasonable steps to ensure that the court and all parties understand the needs to circumstances of those involved in the case. But despite these clear requirements, we see that in practice, these measures are not always applied constantly or effectively. This creates significant vulnerability that can be exploited. When support measures are not put in place or are inadequate, the consequences can be severe. Evidence may be incomplete or unclear because the person giving it is not able to explain their experience or present their story effectively. People may not be able to fully express their needs, concerns, or experience, leading to important information being misused or missed or misunderstood. Procedural disadvantages can affect the outcome of the case because the person is not able to participate on equal footing and their position is not properly understood or represented. Participation is not just about being present in court. It is about being able to be heard, understood, and treated fairly. When this is not possible, the whole process of justice is undermined. So, breaches of duty and legal standards. Barristers have a specific duty to recognize vulnerability and to ensure that the court takes appropriate steps to support participation under Rule 2.1 of the BSB Code of Conduct, acting with integrity, including being aware of the needs of the other party and acting in a way that respects their position. When a barrister fails to recognize vulnerability or actively prevents appropriate support measures from being put in place, they are breaching these duties. This also violates the principle of procedural fairness set out in law, case, and legislation. The court have made it clear that failing to take steps to support vulnerable parties can result in decisions being overturned and can constitute professional misconduct. So, evidential discontinuity, a procedural deficiency. Another critical issue we face in what we call evidential discontinuity. This is a structural problem in how evidence is managed and presented, which creates gaps and misunderstandings that can be exploited to distort the truth. Evidential discontinuity happens when information from different sources is not brought together, connected, or properly interpreted. It means that instead of seeing the full picture, the court is presented with separate pieces of information that are not being linked together or explained or understood in context. For example, financial disclosures may be provided, but they are not cross-checked against tax records, bank accounts, or company's house or other supporting documents that can create the accuracy and the meaning that can be verified. So mostly they cannot be verified. Witness statements may be taken, but they are not aligned with the person's past behavior, actions, or other evidence. So patterns and connections are not identified. Documents and records may be produced, but they are not presented in the context of what the parties have said or in the events that have been taken or that have taken place. So their true significance is lost. The duty of full and frank disclosure is a fundamental principle of family law established in the landmark case of Levacy, formerly Jenkins versus Jenkins in 1985. This principle requires that both parties provide all relevant information openly and honestly, that the court has access to the complete and accurate facts it needs to make a decision. But even when this information is provided, evidenced, discontinuity means that it is not being used effectively when different sources of evidence are not connected and when their meaning is not properly explained. The result is an incomplete, fragmented view of what actually happened. And because the full picture is not available, it becomes easier to present a misleading or distorted version of events as if it was true. We also see the issues play out in what I call the recycler dynamic, a pattern of behavior where the same strategies that are used in personal relationships are repeated in legal proceedings. This dynamic includes repeating cycles of engagement and withdrawal where the party may be involved in proceedings, a time then withdraws and then re-enters and again, and later the strategy of re-entering the proceedings, even when there is no genuine legal basis for doing so, simply to cause delay, increase costs, or gain an advantage, continuing to act in a controlling or dominant way long after the relationship has ended, using legal proceedings as a tool to maintain power and to influence. In legal terms, this behavior can overlap with issues such as vexatious or oppressive litigation conduct, abuse of process, and post-separation coercive control, financial control. The courts have clear powers to address this kind of behavior. In Johnson versus Gorwoods in 2002, the doctrine of abuse of process was established to stop proceedings that are used to misuse the legal system, harass opponents, or achieve improper purpose. In Jamal versus Dow Jones in 2005, the courts confirmed that claims or actions that have no genuine legal purpose can be struck out, and that parties must act in good faith and in accordance with the principles of justice. But these powers are only effective if they are used consistently and properly. When evidential discontinuity makes it hard to recognize these patterns, and when the true nature of behavior is not clear, these powers are often not applied and the behavior continues unchecked. So, breaches of duty and legal standards. Barristers have the duty to ensure that evidence is presented in a way that is complete, connected, and understandable. Under Rule 3.3 of the BSB Code of Conduct, they must take reasonable steps to ensure that information provided to the court is accurate and not misleading. When evidence is presented in a fragmented or discontinued way, and when important connections or patterns are not explained, the information being provided is incomplete and misleading to the court and the other side. This also breaches the duty to act fairly because it prevents the court from seeing the full facts, and it makes it harder for the opposing party to understand and respond to the case. It is a failure to assist the court in achieving justice, which is the core purpose of the legal profession. So why is this? Why this happens and what it means for justice? We have to be clear about what all these dynamic tactics and vulnerabilities mean. When we see these patterns playing out in family proceedings, we are not just talking about legal technicalities or procedural difficulties. We are talking about a system that is being used in ways that undermines its very purpose. The law and the legal profession exists to deliver justice, to ensure that disputes are resolved fairly, that rights are protected, and that everyone is treated equally under the law. But but we see cases being expanded unnecessarily to generate income, turning justice into a commercial product, complexity being created where no complex exists, to confuse, to give disadvantage to the other side, jurisdictions being moved to change and reset the case and to change the narrative and to avoid safeguards that are in place to protect people. Narratives being constructed to fit a desired result rather than to reflect the truth. The effects of trauma and vulnerability being misunderstood or misused rather than being addressed and accommodated. We see the core purpose of the legal system being subverted. This is not a failure of the laws themselves. The legal frameworks we have is built on strong principles of fairness, justice, and protection. The problem is not in what the laws say, but in how it is being applied in practice, the culture. So, and then issues that arise that derive real serious consequences for people's lives. Victims of abuse and coercive control, financial control, are forced to endure further harm, distress, and they are subjected to tactics designed to confuse, wear them down, and undermine their position. Outcomes are determined by resources, influence, presentation rather than the facts in issue and law, meaning that the results of the case can depend on who has the best representation rather than who is in the right. Public interest in the legal system is damaged when people see that fairness and justice are not being delivered as they should be. Then the fundamental rights and protections that the law is meant to provide are denied to those who need them the most. Crucially, all of this involves breaches of the binding duties and standards that govern the legal professions, the Bar Standards Board Code of Conduct, the rules of the court, and the principles of justice that underpin the whole system are clear. But when barristers and legal teams act in the ways that we have described above, they are breaking these rules. They are failing in their duty to the court, to the justice, and to the public. But it is not enough just to identify these problems. We also need to understand that these issues create a context that sets out what we explore in Season 7, Episode 1. What we have discussed today, the powers, the dynamics, the commercial pressures, the tactics that distort truth, and the gaps in how the system works are the foundations of the challenges we face. They help us to understand why some cases go wrong and why fairness is not always achieved. And they show us that to make the system work properly, we need to address not only just individual cases, but the structure, the culture, the standards, and the practices that shape our justice system and how justice is delivered. So, thank you for being part of Silence Screams Loud Strength. Sorry. Let us return to where we started. We have looked at how the legal proceedings can become environments where power, interest, and tactics take priority over truth and fairness. We have seen how the structure of the legal profession can be commercialized. Pressures and strategic behaviors can are combined to create outcomes that do not reflect what actually happens. And we have examined how the binding codes of conduct and legal principles that are meant to protect people are being broken in the process. This is not an easy conversation to have. It is uncomfortable to recognize that the systems that is meant to protect us can sometimes be used in ways that cause harm. But it is not only by being honest about what is happening that we can begin to fix it. The good news is that we do not have to accept this as normal. The laws and the standards we have are strong and they are designed to deliver justice. The problems we have discussed are not inevitable. They are the result of choices, practices, and pressures that can be changed. So, to create a fairer system, we need to ensure that the legal duties and the standards are upheld constantly and that breaches are properly addressed to ensure that cases are managed effectively and fairly without unnecessary complexity or delay, to ensure that all parties equally participate to exercise their rights and that vulnerability is recognized and victims are supported and safeguarded, to ensure that evidence is presented clearly, accurately, and in context that the truth can be properly understood, to ensure that the focus of the legal proceedings remain on what is true rather than on what is most persuasive or most expensive. Justice is not something that happens by accident. It is something that is built through clear rules, professional integrity, and the commitment to put truth and fairness first. What we have explored today sets out the stage for what comes next. In Season 7, Episode 1, we build on this analysis to look at how we can address these challenges, how we can strengthen the systems, and how we can ensure that justice is delivered for everyone, regardless of their resources, their position, or their circumstances. So thank you for joining this in-depth conversation and the deep dive into how legal process and principles collide. If you found this useful, please share it with others who might be interested or who can benefit from this understanding. And if you'd like to follow our work and stay updated on the future discussions, please do subscribe to our platform. Our website has a lot of content that can also help you in your own situations. This is Silence Screams Loud Strength. Until next time, stay informed, stay aware, and let us work together to build a fairer, more just system for all. I'm Samantha. See you next time.